So let's start with the session. Vishal, please introduce yourself.
Sir, I am Vishal Thakur. I am from district Bilaspur, Himachal Pradesh. Sir, my father's name is Sri Nandlal and my mother's name is Srimati Bindra Devi. Sir, I have completed my LLB and LLM from Department of Laws, Punjab University, Chandigarh.
Okay. And in which year you have graduated?
Sir, I have graduated in the year 2020, and sir, thereafter, sir, I pursued LLM, and my batch is 2021 to 2022.
Okay. Okay. So, Vishal, what you are currently doing?
Sir, currently, sir, I am serving as a civil judge cum judicial magistrate in UP Judicial Services. And sir, right now, sir, I'm undergoing training.
Okay. So, you are already selected as a judicial officer. Okay.
Yes,
So,
sir.
Vishal, as you are already selected as a judicial officer in Uttar Pradesh, then why you want to come in Uttarakhand?
Sir, professionally, sir, there is no difference in the judicial service, whether of Uttar Pradesh or Uttarakhand. But sir, personally, I feel more connected to the hilly state of Uttarakhand, as sir, I belong to Himachal Pradesh, and sir, I have been born and brought up in hilly state. So, sir, for that purpose, sir, I think that in long run, sir, I would serve better in Uttarakhand.
Okay. So, Vishal, there is again a possibility comes that in future, if you qualify Himachal Pradesh judiciary, you will be going back to your home state also. Then,
Sir, I think, sir, it is not a viable option for me because the Himachal Judiciary has just completed. And thereafter, sir, if I lose my seniority by around 2 years, then, sir, for the same post, it will not be viable for me. And sir, in Uttar Pradesh, sir, I have joined recently, and there is only 1 month has left.
okay. So, Vishal, as you are already undergoing training with respect to the judicial services, that what you people are learning in your concerned training.
Sir, the training has been divided into two parts. First is sir field training, and second is institutional training, that is judicial academy. Sir, right now I am undergoing the field training, and sir, in field training, sir, we have to visit the civil judge junior division for 20 days, and thereafter, sir, civil judge senior division for 20 days, and sir, thereafter in criminal courts, JM1, CJM, and so on.
Okay. So, in the field training, what kind of observations you have seen so far? Like how many days you have already undergone a training, and what things you have witnessed in that courtroom?
Sir, it was for the first time that I have sat in the court as a civil judge, and sir, I have seen the types of cases in the court. Sir, there are cases relating to declaratory decree, injunctions, and permanent injunctions, and specific performance of the contracts, maintenance, and sir, succession. And sir, the most important part of the civil judge unit division is to dispose of the injunction applications and the commission reports. So I have observed that how the reader of the court helps the judge in disposal of the cases, and what is the task of a judge, and how the advocates deal in the cases.
Okay. So, Vishal, as you said that you have witnessed certain cases which are related to injunction or declaratory decrees and all. So, what is your opinion or your take on the pendency of the cases in the court?
Sir, in my personal opinion, I believe that, sir, the major reason behind the pendency is the dilatory tactics of the bar sometimes. As many a times, sir, they are of the habit of taking adjournments. And a judicial officer is always ready to make an order. But sir, sometimes there are a lot of files in the court that it is not feasible to give order each and every file. So, sir, it depends at what stage the file has reached. And according to that, sir, the order is passed, and so there is dependency going on because of lack of judges in the courts.
Okay. So, suppose as you are already a judicial officer and suppose you are being selected in Uttarakhand also, what things you will take to reduce the pendency?
So first and foremost things it will be, so I will ask my reader that only give the short dates to all the cases which are pending before the court, so that speedy disposal can be made. And the adjournment should be given minimum, so that even if the advocate has some work and no order can be made on the date the file has been put up, then sir, on the next day or within 2 or 3 days the order should be made. So sir, leniency should be not at the stake of the advocates. So this will be my priority.
Okay, good. And this is the one point which you have given. What other things a judicial officer can do so as to reduce the pendency?
Sir, second is, sir, I will ask the parties to go for a alternate ADR mechanism. As sir, we have national lok adalats every in periodical basis, and sir, maximum cases are dealt in lok adalats. Further, sir, there is mediation, arbitration, and even the compromise decrees can be passed. So, sir, it will help the court also and also the parties.
Okay, good enough. So, Vishal, as you are already pursuing your training, when your institutional training will start?
Sir, my institutional training will start in the month July, July 2024.
Okay, okay. So, as far as the UP Judicial Services is concerned, and as you are saying that okay, there is the field training also. Had you seen or witnessed any kind of incident where you find that okay, the things which are written in the book is altogether different from the field?
Yes, sir. There are lot of things that I have felt that what we have studied in law colleges or during preparation, that is totally different what is going on in the court. So first is a Section 5 of the Limitation Act, which says that how to deal with the applications of sufficient cause. So generally in the court always allows the applications on the basis of sufficient cause, and generally courts are granted. Further, sir, regarding the adjournments, only two to three adjournments are allowed in the theoretically, sir. But in practical, sir, there are files pending since 2016, 17, and they are still going on. Apart from it, sir, there is a rule that even if the advocate is ill or he is working in any other court, that will not be reason for adjournment. But sir, practically, if advocate has some work or the party has not come in the court, then sir, in such a case, adjournment is granted generally by the courts.
So it means that whatever is the things which are being written in the law books, it is not suffice because in practical process, those things are not being followed neither by the courts or by the judges. We can say neither by the councils. Yes or no? What is your take on this?
Yes, sir. Yes, sir. I agree with this viewpoint that what has been written in the law books that is not followed with heart and soul. Yes, sir, sir. The basic provision that is the offense, the ingredients, and the basic rules that are followed. But how to deal with them, that is procedural aspects that vary from district to district and state to state.
Okay, good. Vishal, can you please tell me that who is the current Honorable Chief Justice of Uttarakhand High Court?
Sir, Honorable Justice Ritu Bahari is the current Chief Justice of Uttarakhand High Court.
Okay. Vishal, how many districts are there in Uttarakhand?
Sir, there are 13 districts in Uttarakhand.
Okay. Okay. So, Vishal, just tell me that as recently the Uttarakhand government has imposed the Uniform Civil Code in their concerned state. What challenges the judiciary will face while application of the UCC? Like there will be definitely certain changes in the laws as well. So, what challenges will be there in front of the court?
Sir, recently Uttarakhand government has passed the Uniform Civil Code, and so it is pending before the Honorable President to give the assent. And so there are some good things in it that there is uniformity in the personal laws of all the religions, and it has been mandated the Article 44 of the Indian Constitution. But so practically there might be going some problems in the implementation, as there is misconception going on in the society that their religion, their practices have been hampered by this law. So one positive thing which has been made by the Uniform Civil Code in Uttarakhand is that some tribals have been left out from the Uniform Civil Code because sir, they have their own way of traditions, culture. So, sir, they have not been included. And sir, if all the religious people, persons from different religion have been told about the benefits of uniform civil code, then sir, positive results would come.
Oh, good. So, do you believe that the Uniform Civil Code should be applicable nationwide itself?
Yes, sir. In my humble opinion, I believe that this is the high time that uniform civil code should be implemented in India, because sir, it was mandated at the time of making of the constitution that there should be uniform civil code. But sir, the circumstances were not ready at that time. But sir, now some steps should be taken that all the persons should be governed by the same law. Like that, sir, there is a common criminal law, common commercial laws.
Okay. And as in Uttarakhand also, there is some Muslim population is also there. So, what
Yes.
impact over them if the UCC is came into force?
Sir, the Muslim population in Uttarakhand is divided into two parts. So in the hilly areas, there is very less Muslim population, but in the ground, in the later part of Uttarakhand, like in Haridwar, Dehradun, and Haldwani, there is a lot of Muslim population. Sir, definitely, sir, it is going to hamper their rights because there is misconception going on that their Shariat and the laws which have been made for them, it will be hampered because sir, there is a tradition that four marriages should be there, and their shares to the women there is only Quranic shares and residuaries. But sir, in Hindu law we have class one, class two. So sir, some uniformity should be there in view of Article 14 of the Indian Constitution.
Okay, so let's say that the UCC is, let us say that, let's take a supposition, okay, let UCC is being applicable to the whole of the country. Which portion of the country will be more impacted by this?
Sir, in my humble opinion, I believe that the northeastern region of the India will be impacted by this because sir, in Nagaland, Manipur, Mizoram, there are some tribes who have contributed a lot for the country. But sir, they have their own religion, their own set of habits. Like they depend only on the forest. So sir, for them, special rules should be made or some leniency should be given to them so that they can be brought to the streamline of India.
Okay, good. So, Vishal, as you are already a judicial officer and you are serving in the neighboring state itself. So,
Yes.
still, I will ask you that which is your favorite subject of concern?
Sir, my favorite subject is Indian Evidence Act.
So, let's take up on the Indian Evidence Act itself. Vishal, suppose that an incident is being reported to the police officer that there is a lady against whom an offense had been committed, and it appears that the offense is of dowry cruelty, and the burn injuries are there upon a woman. The police officers, as soon as the FIR is being lodged, they called a magistrate, that is the executive magistrate, to get the statement of that victim to be recorded. Now, that statement is being recorded by the executive magistrate, appearing to be a dying declaration. But in the meantime, let us say after 2 or 3 days, another statement is being recorded under 164 of the CRPC also. That is under
Yes.
164 section 5. Now, there are two statements, but there are certain inconsistencies in those statements. During the trial, let's say that the woman dies and the case of dowry death is there, and the husband of a woman is being tried now. There are two statements of the concerned victim. One is before the executive magistrate, another one is before the judicial magistrate. Which statement which be more reliable in the eyes of the trial?
Sir, section 332, subsection 1 deals with the dying declaration. And sir, if there are two statements and there is inconsistency in one, then sir, it will depend upon to whom the statement is made. So Honorable Supreme Court in 2023, in Makhandan versus State of Uttar Pradesh, has laid down guidelines for multiple dying declarations. It said that that declaration will be relied upon, which has more prudence, like when it is made and to whom it is made. So, sir, in my humble opinion, I believe that the statement made under Section 164 should be considered.
So, why you are discarding the statement which is being given to the executive magistrate? Because executive magistrates are equally competent to record the statements.
Yes, sir. Sir, that is not the case, sir. Sir, it depends on what what reliance should be given regarding that.
Okay, okay, good enough. Uh, Vishal, as far as the concept of contradiction is concerned, like during the trial proceedings, a witness is making any contradictory statement. How the counsel can contradict that witness?
Sir, the rule of contradiction is given under Section 145 along with the uh, contradiction. Sir, there is a rule that if a contradiction is to be made by the counsel, then sir, he can contradict him without showing the uh, without proving it, but he can show the written statement that he has made, like sir 161 statement 164. He can attract his attention to it without proving it.
Okay, so do the contradictions are permissible on the statements recorded under 161 of the CRPC?
Sir, Section 161, it can be contradicted, but sir, it can't be corroborated.
Okay. So, do there is any difference between the concept of cross-examination and contradiction?
Yes, sir. Sir, cross-examination means that opposite counsel can cross-examine a person whenever he gives evidence. And sir, the purpose and sir, the method of cross-examination is that the counsel can cross-examine without proving and without showing the document which has been written previously by him. But sir, in case of contradiction, there also no need of proving, but he can attract the attention of that person and he can show the document that you have made this statement earlier and now you are saying anything else. So proving is not there in both of them.
Okay. Okay. Uh, Vishal, coming to the procedural law, can you please tell me that what is the use of case diary which the police people prepare during the investigation?
Sir, the concept of case diary is given under Section 172 of the Criminal Procedure Code. So case diary is maintained by the investigating officer of particular crime. And sir, the evidentiary value of case diary is that it is not an evidence, and the court can refer it for the purpose of clearing the picture. And sir, accused has no right to ask the court to give him the case diary. But where the investigating officer, in order to refresh his memory, takes the aid of the case diary, then sir, he with the accused with the permission of the court can also seek to see the case diary.
And do there is any provision in the Evidence Act with respect to this?
Uh, Sorry, sir, I'm unable to recall right now.
Okay, no issues. So I will be coming back to you, Vishal. Now we are having Garima Khanna ma'am over here. So Garima Khanna ma'am will be taking over and she will be asking certain questions to you.
Okay, sir.
Hi, Vishal. Hi, Arun sir.
Hello.
Good evening, ma'am.
Okay. So, Vishal, a very basic question I want to ask you that you are already a serving judge, right? Now,
Yes, ma'am.
why do you want to, why did you apply here in Uttarakhand and what is the reason behind it? Why do you want to become a judge in Uttarakhand as you are a serving judge in in one of the states?
Yes, ma'am. Ma'am, professionally, ma'am, there is no difference in the judicial service, as ma'am, conditions of the service are same in all the states. But ma'am, I have some personal reasons that I have been born and brought up in Himachal in hilly state, and ma'am, in long run, serving in the judicial service, ma'am, I feel that I will serve better in hilly state, and I will feel intact to it. So, ma'am, for only that purpose, I have applied in Uttarakhand.
Okay, that's good. Okay. So my next question to you, Vishal, is that recently in Uttarakhand, okay, in news there was a news with respect to the women's reservation, right? So, what is your opinion about it? Recently, the High Court has challenged that plea as well.
Ma'am, sorry, ma'am, there was buffering in the sound. Would you please repeat the question?
Okay, so my question is recently in Uttarakhand, there is in Uttarakhand, a reservation of women in government services was this was a very great issue which happened in Uttarakhand, right? Regarding the horizontal reservation of women, where this Horizontal Representation Act of Uttarakhand says that you need to give 30% women's reservation in the government services. Now, recently, what happened that the High Court has told the government, they have just they are seeking government reply on this particular plea, right? So, what is your opinion about it? Like, what do you think that whether it should be given the horizontal reservation to women and that to 30%?
Ma'am, on this question, ma'am, I would refer to Article 15, Clause 3, which says that a special law can be made in favor of a woman or a child. Ma'am, horizontal reservation means to give women special status like that of a man. And sir, ma'am, it is a protective discrimination which can be made in favor of a woman. And in various states, there is horizontal reservation going on for women, like in Punjab and in various other states. So, ma'am, if horizontal reservation is given to a woman, then, ma'am, that will be constitutionally valid under Article 15, Clause 3.
Okay, so do you think that it should be applicable in the state for women?
Ma'am, it will depend upon the quantifiable data that will tell us that how much women are underrepresented in the educational institutions or in the job profile. So, ma'am, on that basis, ma'am, if there is sufficient data, ma'am, on the record, then reservation can be made, which is horizontal reservation.
Okay. Recently, now my next question is that recently government has, you know, in Uttarakhand, there is a scheme known as Agnipath scheme. So, do you know about it? What it exactly talks about?
Sorry, ma'am, I am unaware about it.
Okay, not an issue. Okay, let's ask you some questions from procedural laws. So, what do you think? The furlough and parole are the same thing?
Uh, no, ma'am, furlough and parole are different things. Ma'am, furlough and parole both are reformatory justice system. Well, there is difference between the two, as ma'am, parole is generally granted in those cases where there is some special reason, like there is illness in the family, funeral, or any particular instance. There, ma'am, two things are being seen. First, the convict must have a good behavior. Second, he must have a special reason. But, ma'am, in case of furlough, only the good behavior is seen, and there need not to be any special reason. The second point is that the parole is generally granted in short-term imprisonments, whereas, ma'am, in furlough, it is generally granted in long-term imprisonments. Moreover, ma'am, the period of parole is not considered while computing the total imprisonment, whereas, ma'am, the person while he is on furlough, that period would be counted in computing the total period he has undergone in imprisonment.
Okay, so my next question to you is that is there any provision with respect to furlough in CRPC?
No, ma'am, there is no provision regarding the furlough and payroll in criminal procedure code, and there is only the provision of bail.
Okay, okay, okay. The next question is that in which other statutes do we see the provision of injunction? Where do we there is a provision of injunction, right? So in what all
Yes.
statutes we can see the provision of injunctions?
Ma'am, injunctions are of two types: permanent injunctions and temporary injunctions. Ma'am, permanent injunctions are dealt under specific relief act, whereas, ma'am, temporary injunctions are dealt under specific relief act as well as under Order 39 of the Civil Procedure Code. Further, ma'am, Section 94 of the Civil Procedure Code also deal with temporary injunctions.
Okay, is there any other statute in which injunctions are given? Any other?
Ma'am, right now I only can recall that only Civil Procedure Code and specific relief act.
Okay. What are ad interim injunctions?
Ma'am, ad interim injunctions means that in some cases, ma'am, it is not feasible for the court to decide the injunction. Then, ma'am, for the time being, order is passed by the court to maintain the status quo or to grant a particular order regarding the injunction. That is considered as, ma'am, ad interim relief. And thereafter, ma'am, some time is given, and within that time, the interim application is considered by the court.
Okay. What is doctrine of pleasure?
Ma'am, doctrine of pleasure means that the the persons who are serving in state services, union services, they are holding the office during the pleasure of the government. It is given under section 310 of the Indian Constitution. And ma'am, government can remove any person at any time on the basis of doctrine of pleasure. But ma'am, some safeguards have been given under Article 311 of the Indian Constitution.
Next question is, who is the governor of Uttarakhand?
Ma'am, Mr. Paramjit Singh is the governor of Uttarakhand right now.
Okay. Okay. Who was the first Governor General of India?
My first Governor General of India was Warren Hastings.
Okay. 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 So let's say when we file a plaint, okay. So do
Yes,
we
ma'am.
get a plaint in duplicate?
Yes, ma'am. But it is mandatory under Order 4, Rule 1, and under Section 26 of the Civil Procedure Code that whenever a plaint is filed, it must also be filed in duplicate. And ma'am, it has been added by 1999 amendment to the Civil Procedure Code.
Okay. So what is preventive detention?
Ma'am, preventive detention means, and it is given under Article 22 and under Section 147 of the Criminal Procedure Code. And preventive detention means that before actually occurrence of a crime, a person is detained in the interest of justice and public order. That in order to maintain the public peace and public order, a person is detained before the custody.
Okay. What is default bail?
Ma'am, the concept of default bail is given under Section 167, subsection 2. Ma'am, where the investigation is not completed within 90 days or 60 days as mandated, then ma'am, there is a right accrued to the accused that after the expiry of 90 or 60 days respectively, he can apply for the default bail.
Okay. Um, Vishal, could you tell me more about yourself? Like, except, from where did you do your law? What are your hobbies and etc. Other things?
Uh, Ma'am, apart from my educational qualifications, ma'am, I am serving as judicial officer in Uttar Pradesh Judicial Services, and my hobby is playing badminton.
Okay. So apart from your college or apart from your law degree, what all other interest you have? Or have you pursued any certification course or anything else?
Yes, ma'am. I have opted for postgraduate diploma in human rights and duties. And apart from it, ma'am, I have participated in national moves, uh, intra moves, in national quiz competitions, ma'am, and internships, national service scheme, and various other competitions.
Okay. So as you are serving judge in UP as of now, you must be aware of this BD wala case, right? Have you heard about it?
Sorry, I have not heard about that.
It's okay. It's okay. Okay. So basically it's powers which are given to the agriculturalist, right? So it's an agriculture case basically. It's basically known as a Chintaman case as well, right?
Okay, ma'am.
Okay. Okay, so as you said that your favorite subject is evidence, right? So what is the evidentiary value of accomplice?
When the evidentiary value of accomplice is dealt under various provisions under Section 133, under Section 114, illustration B, and under Section 30 of the Indian Evidence Act. As per Section 133, it says that accomplice is a competent witness and conviction can be based on his uncorroborated testimony. But ma'am, at the same time, under illustration B of Section 114, it says that no reliance can be made on his uncorroborated testimony. But when the controversy has been dealt with by Honorable Supreme Court in Dagadu versus State of Maharashtra, which says that it is a rule of prudence that there must be corroboration of the accomplice, and if there is reliance on his testimony, then when straight away conviction can be based. So when there must be harmonious construction, and it can be conviction can be based on.
Okay. Okay. So are there any other statutes with respect to accomplice in any other procedural laws?
Yes, ma'am. Under Section 306 to Section 308, that deals with the approval, and accomplice is will be termed as a prosecution
Of
witness,
which
and he
law?
will.
Of which law? What sections of which law are you talking?
Section 306 to Section 308 of Criminal Procedure Code.
Correct. Huh.
Yes.
Go on.
Ma'am, there, ma'am, accomplice, he becomes a prosecution witness, and he is made an approval by the court. And ma'am, the power is with the CJM, MM, and Judicial Magistrate First Class.
Okay. Okay. So recently you must have read or you must have been aware of this thing that the Supreme Court is planning to go paperless. So,
Yes, ma'am.
what is your opinion about it? Do you think that this is the right way to go ahead? And if you know that how they are going to go, how they are basically planning to go paperless. Like there are two questions. Okay, first I'm asking about your opinion, right? Whether do you think that this is a right thing to go ahead with? Second, that how they are planning to go ahead with.
Ma'am, right now, this is the era of technology, and ma'am, for the very purpose, three new criminal laws have been passed. Ma'am, going paperless means that the court will make available all its judgments, reportable, non-reportable, to every person through electronic and digital media, and it will be available to. It can be accessed from any server at any place by
But
advocates as well.
Vishal, I just want to interrupt you here. The judgments are still available on every portal if you look at it. If you open the Supreme Court website, you'll get all of it. If you open High Court website, you'll get all of it. So why is there a need of going paperless? Like, what is the idea, logic behind it? What court exactly, what are Honorable Chief Justice is exactly thinking and why he is implementing that, Court will go paperless. And if in case Court goes paperless, do you think that the district courts and the High Court should also apply the same thing? And what do you think? What can be
Ma'am,
the challenges?
ma'am, in my humble opinion, what I have seen in the district judiciary system, ma'am, this going paperless totally, ma'am, it is not feasible in district courts because, ma'am, there is a record room and there are a lot of files crumbling here and there. And ma'am, in some states, there is not basic infrastructure of technology, and computers are even not working in some states and some districts of India. So, ma'am, going paperless will not be helpful for in district judicial system because, ma'am, people are not well versed with technology, though they only deal with the papers that are traditional methods. So, ma'am, some time should be given to the district judiciary till the infrastructure is built up. So, ma'am, it can be implemented to High Court or the Supreme Court, but in district judiciary, ma'am, it can't be implemented straight away.
Okay. Okay. So as you know that there are three laws which have been introduced in India recently. It will be applicable from 1st of July, although. What do you
Yes, ma'am.
think? Like, have you gone through or have you read them?
Yes, ma'am. I have gone through all the three laws, but ma'am, I have not read them section to section. I have read the major changes that have been brought, but omissions have been made.
So what do you think? The changes which have been made in criminal procedure code, will it be helpful in India at a larger pace?
Ma'am, there are some positive things in criminal procedure code which have been introduced, like, ma'am, the provision for video conferencing, search and seizure in video camera, and a trial completion of trial within 3 years. And
What do
these
you
are, ma'am, some
think?
positive.
But I again want to interrupt you here.
Yes,
Vishal, do you think that the idea of video conferencing, seizures and everything, do you think that all of this will be really helpful for a person to get justice, right? Well, does it even, because see, already the law is very complicated. right? Okay, now
Yes,
as you
ma'am.
are a serving judge, you must be looking at it with that perspective also when you are sitting at on dice, right? So already the law is very, I should say very complicated. I should say, there are people find a lot of loopholes when they are when
Yes,
they
ma'am.
are, you know, getting a case and when they are, fighting a case, right? Because again,
Yes,
there are
ma'am.
two parties and you need to hear both the parties at one strata. Right. So do you think that all of these things are not going to hamper or tamper the evidences or, you know, uh, like, will it be really helpful for the people who are exactly going to, abide by this law?
Ma'am, in my humble opinion, I believe that this change which have been brought by the BNSS, then it will be very helpful, ma'am. What is going on right now is that there is search and seizure, but ma'am, there is no record of it. Yes, ma'am. I believe that, ma'am, what changes have been brought, it will help at a larger scale because, ma'am, lacunas are there in every law, and there might be some lacuna in it later on. But, ma'am, there is a lot of things going on, like in search and seizure. Only a memo is presented to the court that this was the search, and only these things have been seized by the investigating officer or by the police. So, ma'am, this to some extent, ma'am, this will help in the fair procedure of the search and seizure.
Okay. Okay. Now my question to you is that um, what is your opinion on midnight hearing at Supreme Court?
Ma'am, there are some cases where midnight hearing has been made. Like even there was in some years back, death penalty was given by the Honorable Supreme Court to the Mr. To accused named Menon. So, ma'am, I believe that, ma'am, Supreme Court has done this midnight hearing in order to give judgment order on the same day without holding with the dilated practice of the advocates. Because, ma'am, in serious cases, it is imminent that order should be made on the same day. Otherwise, ma'am, there will be a lot of chances that tampering of the evidences and witnesses may
But
be
this will to
may be.
happen in every other case also, na? This can happen, and this happens. That is the reality, right? But this can
Yes,
happen in
ma'am.
any of the cases. Then why to sit for a midnight hearing?
Ma'am, it is not a routine exercise. Only in some cases, ma'am, Honorable Supreme Court sits on midnight hearing. Ma'am. And when ma'am, it is totally on the discretion of the court. If they feel that it is of imminent nature that judgment should be made on the same day, then, ma'am, they will take their time and midnight hearing can be made. It is, ma'am, a discretion of the court.
So in which all cases the midnight hearing has happened?
Ma'am, right now, ma'am, I am able to recall the only one case which I am able to recall right now. That is the death penalty given to Menon, who was involved in the terrorist activities in India.
Who is your law minister of your state? Of the state of Uttarakhand? Sorry.
Sorry, ma'am, I am unable to recall.
Okay. Okay. Can a male be raped or sexually assaulted?
Ma'am, in my humble opinion, I believe that, ma'am, a male can be sexually assaulted because ma'am, recently, around 6 to 7 months back, there was a news in media that a male person has been sexually assaulted by some women. But, ma'am, this is disheartening that even today, after the uh, BNS has come into is going to come into force since 1 July, there is no gender neutral rape laws have been introduced, and it is just a copy paste of the section 375 of Indian Penal Code. But, ma'am, I believe that, ma'am, some provisions should be there that sexual harassment of male persons should be added. Like that in POXO, ma'am, there is a word child is used, and male or female child both are included in POXO. Similarly, ma'am, major male should be considered at some provision.
Okay. Okay. So, we hear a lot about eve teasing and all of that, right? So,
Yes, ma'am.
is eve teasing punishable in any of the laws?
Ma'am, eve teasing generally was dealt under Section 354 of the Indian Penal Code, Section 509 of the Indian Penal Code. And, ma'am, if the eve teasing of such a nature falling under Section 375, then there was a separate provision dealing with Section 354 A, B, C, and D. So, ma'am, there were adequate laws dealing with the EUTs in India.
Okay. 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 Now, my next question from your favorite subject is, can an affidavit be called evidence? Can we say it is evidence of fact?
Ma'am, as per Section 1 of the Indian Evidence Act, affidavit is not an evidence. But, ma'am, as per Order 19 of the Civil Procedure Code, affidavit court can ask any person to present the affidavit in the court. But, ma'am, when the affidavit is proved in the court, then it can be considered as an evidence. Because, ma'am, the reason behind it that, ma'am, when the statement is made under oath in affidavit, there is no cross-examination of that person. And, ma'am, without the opportunity of cross-examination, then in the natural justice, ma'am, it can't be considered as evidence and will not be become part of the record of the court. So, ma'am, after it has been proved in the court, it can become an evidence.
Okay. Okay. So let's say I'll give you a situation. Okay. There are two attesting witnesses, right?
Yes, ma'am.
Now, attesting witnesses to a will, right? And both of them are dead. They are not anymore, right? Now, how you will prove a will?
Ma'am, generally proving of a document was is given under Section 61 to Section 67 to Section 73 of the Indian Evidence Act. And, ma'am, in case of will, there must be at least one witness. But, ma'am, even if there is no attesting witnesses, ma'am, there are various other provisions for proving a document. First, ma'am, uh, uh, handwriting expert can be referred. It can be referred to the expert opinion under Section 45, Section 47, and even then court can compare the handwriting or the signature of a person who has attested or who has made the will. So these are the various other methods if the attesting witness is not available.
Okay. Okay. My final question. Okay. As you are a serving judge in UP Judicial Services, um, what if you don't get selected in Uttarakhand Judiciary? What will you do?
Um, Ma'am, if in any case I had not been selected in Uttarakhand Judiciary, ma'am, then, ma'am, I will continue in Uttarakhand Judicial Service till the next vacancy of Uttarakhand is out.
Okay, matlab you will keep on giving the exam, right? Because you wanted to be in your home state.
Yes, ma'am.
Okay. Okay. Thank you, Vishal. Arun sir, over to you.
So thank you, ma'am. Thanks so much. Coming to a certain few questions, Vishal, I would like to ask from you. Vishal, only two, three questions will be there from the procedural part. My first question is that as far as the concept of bail is concerned, okay, as
Yes.
far as the concept of bail is concerned, do there is any time limit fixed by the Honorable Supreme Court to dispose of the bail application?
Yes, sir. In the recent judgment of Honorable Supreme Court in Satyendra Kumar Antil versus CBI, there was a detailed guideline dealing with the arrest and bail, and sir, some time limit was given regarding the bail and anticipatory bail. But, sir, right now I am unable to recall the exact time which has been mentioned. But, sir, it is mentioned by the Honorable Supreme Court in this case.
Okay. And as the process of arrest is concerned, do as we understand that okay, arrest is not mandatory in all the cases. But in the
Yes, sir.
Satyendra Kumar Ansil's case itself, the Honorable Supreme Court has given the broader guidelines with respect to the arrest also. Can you give me your insights on those guidelines?
Yes, sir. Sir, Honorable Supreme Court has some given guidelines regarding the bail and arrest. So first, the Honorable Supreme Court has divided all the offences in four categories. First one dealing with the offences punishable with imprisonment not exceeding 7 years. Second one dealing with imprisonment, death penalty, life imprisonment, and imprisonment above 7 years. Third one is dealing with imprisonment under special acts. Fourth one is dealing with the economic offences. Sir, in the offences which are punishable with imprisonment less than 7 years, in those cases, sir, the guidelines given in Arnesh Kumar should be followed, and the safeguards given under Section 41A and Section 41, subsection 1, clause B. These they must be followed. Like there is no notice should be given before arrest. If he has complied with the notice, sir, then no, there is no need to arrest. Further, if there is no threat to the hampering of the evidences, there is no threat to the witnesses, and he will attend to the court. In such a case, no arrest is to be made. Further, sir, in Siddharth versus State of Uttar Pradesh, even if the final report has been put up in the court, that is not the reason that person should be arrested. So, sir, in such a case, arrest should also not be made.
Okay, okay, good enough. And my last question to you is, Vishal, that recently the Chief Minister of Delhi is inside prison, as in under
Yes, sir.
trial. The case is under investigation. So, as generally we see that the courts are giving bail to the offender, but why the Honorable Chief Minister of Delhi is not getting bail? What actually the concept is there in the Prevention of Money Laundering Act, which is restricting the court to grant bail to the Chief Minister?
Sir, there are some stringent laws like Prevention of Money Laundering Act, Prevention of Corruption Act, and NDPS Act. So in these acts, sir, the provision of bail is very strict, and generally the offenders in these acts they are not granted the bail because the bail is the discretion of the court, even if in non-available offences. And sir, if the court finds that it is in the larger public interest that bail should not be granted, then it should not be given because sir, there will be ruckus in the society that a chief minister has been arrested, and if he is on bail, then sir, definitely sir, various people, political persons will start in the race of accusing the court and the authorities. So sir, this is the higher risk.
But Vishal, my counter question to you is that there is a general rule which we are having that every person is presumed to be innocent unless his guilt is proved. That is the general rule which we are having. But
Yes, sir.
the money laundering act is on the other hand, it is saying that the person is presumed to be guilty unless he is proving that he is not.
Yes, sir.
So why this kind of special exceptional rule is there in this law?
Sir, the same rule was laid down by Honorable Supreme Court in 2022 in the Madan Lal versus Union of India. And so this was the rule that there is no presumption of innocence considered in money laundering act because the money laundering is kind of offense against the country that you are uh, hampering the exchequer of the nation. So sir, this is considered as a serious offense that how a person can have differential attitude towards the exchequer of a country. So sir,
Oh,
for this reason, sir, this is considered that
oh,
no bail should be granted.
good enough, good enough. चलो ठीक है विशाल, I hope you got all the clarification